Hello, this is Nikki Kyohoho, CEO and co-founder of the Direct Selling World Alliance. Welcome to the Executive Forum. We're so excited today to have a very special guest, Mr. David Einstein. He lives in Carlsbad, California, and he's an attorney and has been a lawyer in our industry for over 28 years. He is licensed to practice in California and Arizona. He is also admitted to practice in a particular case in a dozen other states and federal courts. David is now an alliance partner of the DSWA and has been a supplier member of and spoken at industry meetings and seminars sponsored by groups such as the DSA, the ANMP, which was the DRA, and the MLMIA. Lots of letters here. And he represented many network marketing and direct selling distributors and companies in courts, arbitrations, and mediations since 1989. He has also served as a distributor director and shareholder of companies in our profession. For 15 years, David did legal work to bring a number of direct selling companies into legal operations. Now, David Einstein has turned his attention to being the network's mediator. And that's the mediator for our industry, serving as an impartial mediator to facilitate resolutions of disputes arising in our industry. With David's vast legal experience and record of accomplishment in the industry, you're definitely going to want to share this webinar with your executive team and your professional colleagues. I'm happy to introduce David to you. Welcome to the webinar, David.
Thank you, Nikki, and it's really an honor to be with you today. Appreciate the opportunity.
Well, we appreciate having you be part of our profession. Now, today what David's going to be talking about are reasons to mediate an MLM legal dispute. Because for many years, we've had a lot of people have gone to court over lots of things and invested a lot of money, and David has experienced all that. So today he's going to be giving you those reasons why you want to mediate versus just go to court. So David, take it away.
Well, thanks, Nikki. I really appreciate an opportunity to get with you and your people all around the world. I do have, I think, an important topic to discuss today, and that is mediation. And I want to give you the 5 reasons that I think are really important to mediate an MLM legal. And we'll talk about what legal disputes might come up in network marketing, direct selling sorts of situations. But let me get right to the reasons why mediation is really important. First of all, just turn to another slide here, if I can do that. If you're a company owner or executive, mediation is your friend, even though your first intuition might be when you're challenged by a distributor that you've confronted for not following the company's policies and procedures, is to use the company's superior cash flow to throw the biggest law firm in town at the distributor and her lawyer. And you think that it's okay, you're ready for the fight, let the David versus Goliath battle begin. Well, that's known as making an example out of a distributor that has gone astray, at least in your mind and in your company's view. However, if I go on to the, just a little problem. There we go. If you're a company owner or executive and you talk to your lawyer about the possibility of a lawsuit against a distributor, perhaps a distributor's followed a wrongful termination lawsuit against your company. Your lawyer tells you it's going to be expensive. There's going to be fees, not only her firm's fees, her law firm's fees, but also the cost of transcripts for depositions. Experts and the like are going to almost always run into the 6 figures if the litigation runs its full course. Now, when I say full course, everybody knows and have heard terrible stories, and many of them are true, about litigations lasting 3, 4, 5 years or more. Normally, typical commercial litigation of a complex matter, such as we see in the direct selling field, will run 1.5 to 2 years before it goes to trial. By that time, yes, the six figures, we're into the six figures in most lawsuits, really, frankly, on both sides. Both sides of the lawsuit are already up to these kinds of costs because of the exorbitant costs of deposition transcripts and the fees themselves. I mean, when they add up, they're exorbitant. Everybody in the process, I'm not laying any blame on anybody trying to run up the score in terms of costs in litigation, but it sure does happen as a natural consequence of today's mode of litigating commercial litigations. It's comforting, I think, to think of an alternative such as mediation to a complicated lawsuit or arbitration. Mediation is a one-day procedure, and it costs 10% or less of what it costs to litigate. Usually a mediation is going to cost much less than 10% of what it costs to litigate. After the multiple days of testimony preceded by depositions of witnesses getting ready to go to trial, and then at trial, these things are going to add up. And not to mention the possibility of an appeal for litigation. Mediations are final once they have been settled. If the parties can come to a settlement during their one day of working on it together with the help of a mediator, then that's a done deal, and there won't be any appeals, and there will not be any further litigation. It all comes to a halt. If it's already started, it comes to a screeching halt. And if it hasn't started yet, it never happens. So mediation can be a very helpful, cost-effective means of settling disputes.
You know, David, I've read in your lengthy bio and your background that you went through a lot of training on this mediation. And earlier, as I mentioned, that you are a lawyer for, the couple of states that you are licensed in. But with mediation, you can go anywhere. Is that correct?
That's correct. As a mediator, you're not required by the states to be licensed, be a licensed member of the bar. I've appeared, as I mentioned, I guess, as you mentioned earlier, Nikki, that, I've appeared in a dozen or so states in their state and federal courts on behalf of clients in different cases. And every time I've had to either be a member of that bar, which I am of California and Arizona, as you mentioned, but also if I'm in a state which I have gone to, like for instance Texas, which I've been in frequently, or Florida, or any other state around the country, I've had to ask the court to admit me pro haec vice. It's a Latin phrase, it just means for the particular case. And you also have to get a local counsel as your sidekick, or else the local lawyers get upset, that there's a lawyer from another state coming in to litigate a case in their courtrooms. That's a kind of a protective attitude, but it is the case, and that's the way it works in the U.S. and then other countries. Same thing. You have to follow their rules, and if you're in mediation, it's not considered the practice of law, and so I, as a practicing attorney, don't have to be licensed in a particular jurisdiction to go someplace. To mediate the case.
And even in other countries, you said that you can go to Australia or countries where they are English speaking. You can do that type of work.
That's right, and that is something that is a big advantage for the parties that are litigating, not to have to have both sides and all of their people. Their key witnesses, the associates that are working on the case with the partner in the firm. After all is said and done, you could be talking about maybe a total of 10 personnel per side, including the client and the key witnesses and the attorneys and their clerks, and so that gets very expensive. Whereas the cost of my travel, of course, is borne by the parties to the mediation, but it is much less than would be the cost if they had to travel to the U.S. to meet with a mediator in the U.S.
Well, that seems like another cost savings there too. So what kinds of challenges are typically involved in legal disputes in our industry that you've experienced?
Well, that's a great question, and it commonly takes the form, Nikki, of wrongful terminations where a distributor feels that she's been wrongfully terminated by a major direct selling company. Usually if the company is brand new, there's not going to be litigation. That company may just have to shut its doors, or perhaps a distributor would not be encouraged to even consider litigation against a brand new company that hasn't proven itself. So you generally find litigation in the MLM sphere when you're dealing with key distributors of major successful direct selling companies. And that's when they can become at odds in a very expensive litigation process, and that's where mediation really, quite frankly, makes the most sense in terms of cost savings.
And what I'm hearing you say is it's generally the larger companies, because the smaller companies, the distributor is not going to go after them unless they think they have deep pockets or that they're, you know, there's something to gain there.
Typically, that's the case.
Got it.
All right, so well, let's take another example. Let's say that you are a distributor, a key distributor. As I said, it's usually the key distributors that end up having to litigate their differences with the company, or at least become involved in a major legal dispute that isn't resolved, or perhaps not even resolvable by the parties themselves, because there's just too much water under the bridge, bad feelings, hard feelings, whatever you want to call it. It's going to resolve itself in litigation, or in the alternative, mediation. Yeah, typically, as you asked me about what is typically involved in an MLM, direct sales, network marketing litigation, it's typically a wrongful termination, but it's not always. But in a wrongful termination, I've set forth a scenario on this slide that indicates what happens sometimes in our industry. Hopefully not a lot, but it's enough that it's a problem. You have a jealous distributor who envies your success as a key distributor in a company, and that distributor may have a special relationship with the compliance director or the company CEO or not, but may give compliance or the CEO or both information and be promised confidentiality, even though that may not be possible ultimately for the company to actually deliver on such promise, because whatever happens in this context is subject to discovery and litigation. So that's conceivably a problem ultimately for the company. If they go into litigation, their records can be subpoenaed by the attorney for the distributor, and it can be determined who the deep throat, so to speak, of this information is. So the deep throat distributor rats on our example distributor, our key distributor in this example, and she is not particularly liked by the CEO anyway. So the CEO perhaps even eagerly pounces on the allegations against his key distributor to first suspend and then terminate that key distributor without disclosing what, if any, evidence exists to support charges which are largely hearsay. Not always. Sometimes everybody involved in a conflict knows all the facts on both sides of the conflict. That is rare. That kind of transparency is rare in our industry. It does happen, but it doesn't mean that won't still result in some kind of litigation. So typically the termination of a key distributor is a red flag for the company, and of course for the distributor who loses their income stream. So that's one element of litigation. But you can imagine that companies in our industry are just like other companies in the respect that there are conflicts amongst board members, there are conflicts amongst shareholders, there are conflicts that result from employee terminations by the company. And many times those kinds of conflicts involve distributors and as witnesses, and perhaps even their downline organizations, and the types of things that you might also see in a wrongful termination type of a litigation. So the key issues of MLM, network marketing, direct selling, are involved even when it's not distributor versus company, but it's employee versus company, or supplier versus company, or executive against company, or executive against an executive of a company. A lot of times there's a lot of money at stake, as you know. In our industry, successful players in our industry are earning, if the company's successful and the cash flow is right, they can earn a lot of money, and it has a tendency to make people really focus on what their legal rights are when a problem comes up, because there's so much money at stake. So that's really anything that involves MLM issues, such as downline organizations, such as computer software that keeps track of these things, such as executive firings by the company for disputes with distributors, or perhaps conflicts of interest in the company that may or may not involve distributors. So it covers the whole gamut, and really mediations are equally positive in the respect that they can resolve these disputes in one day, and for a small fraction of the cost it would take to resolve these disputes in many days.
You know, David, it sounds to me that part of this is how the company is set up in the beginning, with their policies and procedures, with their non-compete agreements, with their their staff, with their agreement that the distributor signed. It seems like if all those things are handled properly and put into the correct, context, it could prevent a lot of these things.
Yeah, it's really important to have a qualified direct selling attorney prepare the policies and procedures right out of the gate for even a new company, because these policies and procedures, you're still right, Nikki, this is really the heart of, and the basis for many disputes in our industry, the disputes that do exist. And I'm not saying that we're all at each other's throats, that's not the case at all. But when there is a dispute, it often relates to a provision of the policies and procedures. And so we have some great MLM attorneys, direct selling attorneys in our industry who help their clients, companies in the industry, get on the right footing right from the get-go. And if they don't do it early in the growth of their company and the existence of their company, they could be really asking for trouble. So I know you've had a number, and you do have a number of very qualified attorneys who bring companies into operations who are associated with the DSWA, and I see a whole, we only have really a handful of those kind of specialists in the industry, but a lot of them are in the DSWA, of the relatively few attorneys who actually specialize in this area of law. So I think you can be in good hands. You just have to make the decision as a company owner to spend the money that it takes, and usually it's quite reasonable up front, to get off to a good start with your policies and procedures. So if I were to continue with our example of the key distributor, reason number 2, the key distributor in the company, and what are they going to do when there's a dispute? And there's a lot of money on the table for them, and they don't have perhaps an income other than this particular company that they're having the dispute with. They talk to an attorney, perhaps 3 or 4 attorneys, and it's really hard for them to find an attorney who specializes in the kind of legal issues that we find in our litigation and the direct sales, network marketing, and MLM industries. So usually they're going to get some decent advice from somebody who has no experience in our industry and the legal issues surrounding it. And that decent advice is that it's going to be very expensive to litigate, because any attorney, regardless of their qualifications, is going to be taking on a very complex commercial litigation if he or she should accept the case from the key distributor. That is just the nature of commercial litigation and the complexities involved in our industry. And most, high dollar value or possibly high stakes, let's just say high stakes litigations, they are going to involve some complex interactions and commercial issues, which is going to cost money and serious money to litigate. 6 figures on both sides is not uncommon. So they'll tell you that you're going to be paying an hourly rate, and that hourly rate is not cheap usually. I don't need to name names or state numbers. Everybody knows what hourly rates can be in these days, and they're going to want a hefty upfront retainer in order for them to represent you. That's to basically protect themselves and their firm from the kind of commitment that they're making. They're going to be allotting a large portion of their time to represent you and to do a good job for you, and hopefully give you a chance to win the litigation as the key distributor. So this can all be avoided at any stage of the litigation or before it's even started, which is preferable, so that the expense meter is not turned on. And I'm not just talking about the attorney's fees, I'm talking about the costs we've already mentioned, the cost of the transcripts of witness depositions, believe it or not, can average $1,000 a pop. And then when you add in the videotaping and the cost of the videotape version and the specialized software that has to be purchased to show it to the judge and jury or arbitrator, you can be talking over $2,500 per witness deposition. There could be 10 depositions taken in a federal case or a state case. And even arbitrations now often incorporate the clause where the parties agree to arbitrate often says that they're going to follow the federal rules of procedure, which means there's going to be 10 depositions perhaps in the case or more. So these costs, as you can imagine, if you were to have 10 depositions in your complicated commercial litigation, which we call MLM litigation, you're going to be looking at $25,000 on both sides just for the cost of the transcripts. And then the cost of going to trial, much more expensive. So I've talked about that a lot. I'm not trying to scare people, but at the same time, I want to be realistic with people because I've seen it. You know what, Nikki, I have practiced law not only 28 years in this industry, but for 41 total. So I've seen a lot of commercial litigation, and I know firsthand what the cost to the clients is, and it's unfortunately it's gotten to be unaffordable even for the companies to litigate these cases. And so mediation is just an alternative. It's an alternative dispute resolution mechanism that's much less expensive than arbitration and, of course, court litigation. So I rather than try to scare people into mediation, I just reason with them about what do you really, realistically, what do you think your budget is going to be to keep this litigation alive for the time it's necessary to reach a result, and by a third party, judge, jury, arbitrator, who you don't know and who may not like you. And why not take it into your own hands along with the other side with a facilitator who is an impartial third-party mediator, an attorney mediator, hopefully, and get this resolved within a day and save yourselves a ton of money on both sides.
Part of that, David, I think, I don't know that people think about this at the time, but when you go to battles, per se, in a lawsuit, it takes a lot of energy and time to do that. So it's like, if I do this, what is that going to take away from my ability to earn income now, or to grow a company now, and so on? And sometimes you have to realize, what is it really worth?
That is,
you feel like you have to win, or what?
there's very few cases in our courts or in arbitrations where the just result is always so clear that you can predict more than a roll of the dice could predict. It's just sad that we believe that justice is a pinpoint accurate. Many of us have grown up with that belief. It's not. So anyway, take it into your own hands if you can. Resolve it by mediation. Just get the case settled. Go on with your opportunity. Don't suffer the cost of a lost opportunity as a company or as a distributor, a key distributor, because you're hung up in litigation and you're tied up financially and emotionally in a draining, very difficult experience, getting ready for trial, going to a deposition, testifying in a deposition, testifying in trial, having all the stress. It's not what you do for a living. That's what lawyers do. And so if you concentrate on your strengths, what are they going to be? Is it winning a case, or is it making a business profitable and making your living from our industries awesome opportunities? So I think everybody's got their own opinion of that, and I'm pretty sure I know what most folks think. They would prefer to avoid the litigation and avoid losing income opportunities by being hung up in it. And if you take a one-day proceeding such as a mediation and get issues resolved, that can be so much of a blessing for everybody involved. And they're consummated by written agreement, so it's legally enforceable. All right, so let's not forget the lawyers. There's the lawyers that are listening or that our listeners are going to be talking to about their legal dispute, whether they're the companies or the key distributor. Those have an awesome responsibility that they have to deliver on. They have to be they have to be the representative, the legal representative that helps usher them through the process. And it is an awesome responsibility, and it costs the clients a lot of money for that lawyer to spend their time on their case over a period of months or years. And so, yeah, they get paid for it, but generally speaking, they will earn their fees. But sometimes those fees and costs of the litigation or arbitration are just unaffordable to the clients, and that's often the case nowadays. So attorneys are wising up to alternative dispute resolutions such as mediations, and especially including mediations, a one-day way to turn around the fortunes of your clients by going to the mediation, actually preparing for it before the mediation by submitting a mediation memorandum to the mediator. Both sides do that, so the mediator can become informed about the legal and factual issues. It's a briefer version of what would be submitted in a court or arbitration, but it's still very informative for the mediator to have that kind of information in advance of meeting with both sides. So that's part of the responsibility in the mediation of an attorney, then to go to the mediation with the client to say what the client's strong points are and to reflect on the other side's arguments to some extent in mediation is also part of the attorney's role. So they get paid for that, and they work hard and earn their fees at a mediation. It's not just, well, let's go settle the case, and it's just that simple. It's a one-day experience, but it can be a really life-changing experience. And we're going to find out in the next slide or two why that might be. But the attorneys, again, they earn their keep, and they can do their client a service by saving that client a lot of money, whether it's the company, distributor, supplier, anybody involved in our industry, executive. That attorney for that client is going to have to work hard to make sure that client is well represented, even if it's resolved in a mediation. So there is a disincentive. I don't like to dwell on this for attorneys to litigate the cases in court and arbitration because of the fact that, and their billings are legitimate in the usual case. There's nothing unethical about attorneys. A case can be very complicated in our industry, often is, usually is. Attorneys, again, they earn their money in their litigation on behalf of the clients. There is nothing wrong with that, but at the same time, it gives the law firms of the attorneys and the attorneys themselves perhaps a bit of a disincentive to settle the case early in the conflict, because then they might generate less in the way of attorney's fees. That is it's not a slander on my profession, it's a truism, and I know it. I've dealt with it for 41 years. It's it's there. It's part of what attorneys do. They have to be above that, and they can show their client they're above that by strongly recommending mediation and then strongly participating in the mediation on behalf of their clients in the best interest of their clients towards making a reasonable settlement if one is in the offing, if one's on the table, or if one can be summoned in the process. Theater. So that's a very ethical thing for an attorney to do, to put her own interests aside and her firm's own interests aside and simply believe that those interests are being furthered by well representing their client and getting more business from that client, because that client is going to generate more legal business by being able to be involved in more business if they're freed up from the litigation track, which can last for years, as you know. So that's the third reason, is that the legal counsel is really serving a very useful purpose to his client if that case can be mediated successfully and litigation can be avoided or curtailed or avoided altogether. The fourth reason, Nikki, is, believe it or not, mediation can actually be giving both sides a day in court without going to court. Now, on this slide, I obviously put quotation marks around day in court. You don't go to court with a mediation. You go to an office or a conference room, or an office with usually at least two conference rooms, so that both sides can caucus when they're not in a joint meeting with the mediator. So it's not going to court, but it is like getting a day in court. And I'll tell you why. It gets something off of their chests. They get a chance, the clients get a chance to speak, the attorneys can speak, but the attorney's role should not be as much of an adversarial role as you would find in the courthouse or in an arbitration. It should be more of an informative role for both sides to learn the motivation and the reasons that the other side might have for their point of view in the litigation. After all, Nikki, I've never really run into a litigation, and I have practiced a long time. I've never run into a litigation where either side really believed that they were in the wrong. Isn't that funny? You would think.
It is.
You would think that it happens all the time, because maybe we see on TV where it's obvious that somebody's messed over somebody else. Well, isn't that obvious in real life? And you need to understand that one party isn't going to necessarily understand the other side's point of view until they see the other side and meet the other side in a very stressful situation, which is a mediation. And it's a one-day event, but it can be grueling and it can be long, and yet it can make all the difference in the world between resolving or not resolving a case and being forced into either dropping it or pursuing it to its limits in court or arbitration. So it is, yeah, just because it's a one-day proceeding doesn't mean that it's not difficult. It's hard work for everybody involved. And it gives the clients a chance to get past the emotional overlay. And you know, there's an emotional overlay from the fact that they have this grudge, they have this problem, they have this thorn in their side that's keeping them from accomplishing what they should in life. And I mean, both sides have experienced these emotions. So this is the beauty of a mediation, is the cathartic effect that it has on the person bearing their soul, about how they really feel about the other side's actions, which they feel resulted in a legal conflict. Most people don't until they hear it from the other side, and the other side is bearing their soul. They don't really get it. You know, it's more impressive when that happens in person, where both sides are in the room, you know, or they're key, you know, the representatives, not just the attorneys, but the actual plaintiff and the actual defendant in the room. And if it's not already in litigation, they're not called plaintiff and defendant, but maybe they're a distributor in their company. In our example, if the distributor is there in person and the CEO of the company is there in person, they both get a chance to tell their side of the story briefly and in a way that's confidential. It's not on the record. It can't be used in a court of law or an arbitration. It's considered irrelevant as a matter of law. I know that sounds funny to say it's irrelevant, because it could be so relevant, but from a legal perspective, it is considered, under the rules of evidence, irrelevant what happens in a mediation. So you can bare your soul, get something off your chest, feel better about it, tell people how you really feel. Now, that hurts when you have to listen to that. Can you imagine, Nikki, what it would be like to sit across the table from somebody who's hurting so bad?
Mm.
And chances are both sides are really miserable.
I think sometimes this is just a lack of communication. People not really understanding something or not talking about it. Some people just let their anger take over everything else. And I've always said for 100 years, when emotions are high, logic is low. And so when we are highly emotional and highly angry about something, maybe we don't see the logic in the other party's view. So this is a chance for them really to let go of some of that anger and possibly to be open to hear what else is possible.
It is painful, but you know what they say, no pain, no gain, right? So after participating and enduring and being part of that, it's like, you know, they used to resolve issues between people by a trial by fire. You know, the stories about that. There are other means of trials, such as dueling. We've come a long way now that we can settle our differences in court and arbitration, although I guess the joke is kind of on us as a society that turned out to be so expensive. But I think it still beats dying in a firestorm or in a duel. Being facetious here, if I'm not offending anybody, but that's the way it used to get resolved. So we've come down to this, but we're trying to get past this expense part of the confrontation. The mediation is not a way to avoid confrontation entirely, because the people are going to be told and asked by the mediator to be respectful. They should check their ego at the door to a large extent. They should check their attitudes before coming in the door to the mediation, and be businesslike in the sense that our industry is a business. We should be businesslike. in our dealing with everyone else in the industry. And that requires some respect, and a little respect goes a long ways. So after they get rid of that emotional overlay that they were burdened with at the start of the day because of the bearing of their soul, by being able to tell the other side in the other side's presence what it is that motivates them, what moves them to believe on their on their side of the case, they have a sense of relief, and it clears their mind after, you got to give it time. You don't just walk into a room, speak for 10 minutes, and then, okay, so now I'm ready to settle this case. No, that doesn't happen. I mean, it takes a day for good reasons. There has to be a process unfold in the mediation. And this, up to this point, is what I've been talking about in terms of the bearing of the soul, the cathartic effect of telling one story. That's a necessary part of it. And then there is another necessary part of it, and that is some time. So the parties take a break, they go to their respective rooms, and they caucus. And caucusing means just that they huddle, the attorney with the clients, and the mediator shuttles back and forth between the rooms to see where each side is at, and to give them some time and maybe bring in some lunch or send them to lunch. It's going to take more than an hour or two. If your mediation is over in a half day, usually I have found that it means it wasn't successful. The successful mediations are those usually that go into the afternoon, go into the late afternoon, go into the early evening, maybe even go into the late evening before a breakthrough. So that's why I say it gives both sides an opportunity to have a day in court, because in many respects it's like having a day in court without all the bells and whistles of fees and costs that you would also be experiencing getting your day in court. So the thing about mediations, this is reason number 5. Mediations are only binding where there's an agreement to resolve the dispute. And if there's no agreement in that day of mediation, and by the way, just in case you were curious, yes, some mediations do go for more than one day. Some mediations are unsuccessful during that day, and with capable follow-up by the mediator and the attorneys for the other side, both sides, if they continue to communicate, lo and behold, there can be a settlement even after that day of mediating. And perhaps the parties will even agree that it would be productive to continue on for another day after the first day. But that is not necessarily the optimum. It's better to kind of count on your chance to resolve the case in this way, in this cost-saving way, this energy-saving way, this grief-saving way, this time-saving way. It is better to do that. It has to be done. If you have the goal in mind, I got to do this. If you have the constraint that is somewhat of a, I guess it's not really a necessary constraint, but it seems to be needed in many mediation situations, that the parties have some time pressure to get the mediation done and get the settlement done. Otherwise, they're going to come back and forth with little or no progress in their offers to get the case resolved. And it does take time to do a mediation, but it's also necessary to limit the time that's allotted for the mediation so that parties don't get the feeling that they, quote, can take all day, close quote, to make a counteroffer or to do this or do that, because that's really counterproductive for the process. It doesn't help the case get resolved. So I say, because it's non-binding, it's confidential, it's off the record, even if it's not resolved. If it is resolved, it's still off the record and confidential. It is binding if it's resolved. And you're done. I say nothing ventured, nothing gain. It's worth a shot. What can it really hurt? It's a way to understand the other side's motivation and what moves that other side in the litigation, if you continue the litigation, or to help you to understand how that other side feels in order to help you to get to muster up the intestinal fortitude it takes sometimes to settle a lawsuit or settle a dispute before it's filed in court. So I say this is a good way to avoid anxiety and grief in your lives, and that's from experience, personal experience on behalf of clients, many clients, many situations. If you can avoid going to court, you should. And this is when the stakes are high, when the stakes are high enough, and you don't feel you can afford to avoid a conflict with the other side, at least consider mediation and move into that mode as quickly as you can, and if possible before the litigation is filed, but it can be done at any time during the litigation. Oftentimes judges will refer cases for mediation during the middle of the case moving on towards trial, and it can even be handled by a mediation during a trial. It's not limited in terms of when it can actually happen. Sometimes it happens after a trial and one of the parties says they're going to appeal, but is willing to mediate in order to avoid an appeal. I mean, it's not something that has to be done early on in the dispute, but just think how much money you would save if you could save the cost of all of that necessary representation by attorneys in our law firms. So that's why I'm on a mission, Nikki. I want to make peace in our industry. Even though we have a great industry, we do have issues that we need to take care of.
I would agree, and I think you did an outstanding job of explaining the reasons why to mediate and gave a better understanding of how it would work. So I know the way you look at it is mediation is a bridge to a future negotiated settlement. And as we all look at this business that we're in and we love it, it would be so nice if we could simplify this process where, one, all companies had the right policies, procedures, had the right agreements in place, and everybody did the right thing. And if the field honored the agreements that they signed, we could prevent a lot of these things. But I'm just happy that you landed here in this role as a mediator, because I think it will significantly impact the future of our profession and the amount of money that is spent on litigation that could have been avoided. So David, I know people are excited to learn how to contact you. On the slide, your phone number, 858-243-1425, his website, his email. Please reach out and connect with David if you have questions or you want further understanding, or you're caught up in a situation that you want to find another possibility besides litigation. So David, any last minute words from you?
I just want to thank you again, Nikki, for this opportunity. It's very much appreciated by me, and I hope that the folks who have listened to this and seen the slides have enjoyed the presentation. Be happy to, I know that you're recording this, and I would strongly recommend that people who are considering litigation perhaps give another listen to this at some point in the future.
I would agree. Thanks again, David, and thank you everyone for taking the time to listen to the DSWA Executive Forums. You can always go to the page where they're listed. There's many from the past. This happens to be a current one that you're getting now, but when you go to that page, you'll see there are multiple other forums that we've done throughout the years with some great content for all of our corporate executive teams. We wish you all the best, and make this your best year ever. Goodbye.